Hello. Welcome to Making Law Simple. My name is David Helm, a licensed practicing attorney in the state of Michigan. And with me today from the land down under is Hella Excited Utterance. Welcome.
I'm a fake lawyer.
You're a fake lawyer, yes, but you know all the lawyers, or you know everything, all the law better than lawyers. Jeez.
I do. In fact, I've built quite a few.
Yeah, nice. With us, I guess we also have Salvador. Welcome.
Hey, welcome back.
Welcome. We got Lefty in the chat and Jung. Thought it was Making Law Silly. No. It's not Making Law Silly. Well, it could be. But today, so today I brought Excited and Salvador on the stream today because I wanted to read through a transcript, and they're really good at reading through some of these things. If you ever watch are you still doing the Sunday streams where you go through the tweets?
Haven't been for a while. Probably bring it back in a few months. Yeah, after Karen Reed, because I do not want to cover Karen Reed.
Yeah. I'm going to stay away. I'm going to let others cover Karen Reed. I have a trial coming up on Monday that I'm going to be streaming with Nick, which is not the Karen Reed trial, which I'm excited about. But I ran across this case. This is from 2019. This is a plea deal. All this hearing is. It's just to say, put on the record what the plea offer is in a criminal case. And so if you don't know, 99.9% of criminal cases plea out. They don't go to trial. It would be impossible to try them all. So the prosecutors usually make, they overcharge and then they give little plea deals. And if the defendant accepts it, which a lot of times they do, then they get sentenced according to that. The key here, though, is that in order for the plea deal to be acceptable and valid, it needs to be knowing and voluntary. So the defendant has to know the plea deal, what it actually is, what the sentence is going to be, as well as know what his rights are, what his possible sentence could be if he didn't do the plea deal and was found guilty at trial. And then it must also be voluntary. It cannot be coerced in any way. So, so that's what we're going to talk about today, because we have, in fact, two twin brothers, identical twin brothers, so they say, that are being charged with various crimes, and they're holding a plea hearing together. And what I want is the audience participation. Is like, when I don't know how to do this yet. I haven't thought about this, but if you're in the chat and you're following along to this reenactment of this plea deal or plea hearing, if you see something like off, like I don't think that's right, I want you to be able to put something in the chat and like throw up like warning signs. What?
He doesn't mean Dolly's mustache.
Yeah, not Dolly's mustache. Yeah, no, we'll forget about that. But I don't know what. Guilty. Well, here's the thing. These two guys are guilty, right? they're guilty by their own admissions, but they might not be guilty of the things that the state says, right? That and what the state charges them. And so we're not really arguing over guilt or innocence here. This is like, is this a knowing voluntary deal? And are they guilty of what they're actually pleading to? So you missed the question. Well, so the question is, there's really no question. It's like, there's just like, as soon as I started reading this, I was like, something's off. This doesn't seem right. I have a whole host of issues. And so what should we put in the chat? What should we have the chat put in when when
there's something off?
Yeah, when there's something off. If you in the chat and you spot something off, like put a 1.
How about a little poo?
A little poo. Yeah, do a little poo emoji. Yeah, a little poo emoji. If it smells like shit, put a little poo emoji in the chat. Yeah, there we go. Because I feel like there's a lot of issues here. And then we have a or the Supreme Court of Michigan actually made a ruling on this in 2014 or 2024 rather. So like 5 years later, the Supreme Court finally said, not yet. We're not to it yet. I know that's for Sal, but
gonna hurt my feelings.
Yet. Yeah. So anyway, so we're gonna go through it and see if the Supreme Court agreed with y'all. All right. So that's kind of the experiment we're gonna do here. I don't know if this is gonna be a good stream or a horrible stream, but I've got Sal and I've got Hella here, and it's gonna be a good time for me anyway.
And there's gonna be poos.
And there's gonna be poos raining down in the chat, so it's gonna be a good time.
How much better can it get?
All right. So we've sort of like prearranged, I think,
Yeah.
who's gonna play what. So the court
Yeah.
is gonna be Hella. It's a woman judge.
Oh, it's the woman, and she's gonna be Hyacinth.
A questionable plea hearing. Are we discussing
Well,
self-dating? Yeah.
I mean,
I need a taint emoji. You know what? I should have my emojis back, actually. So I've been working with YouTube. I think I monetized again, although you can't super chat me right now. I still got to go through some motions, but I set up my memberships. I don't know if they're live yet. Anyways, we're on the right track, so we might be monetized again. So yay.
Yay.
Based reading stream. That's exactly what it is.
Yay, amen. How's it going?
So, but welcome everybody in the chat. And I know I haven't said hi specifically to all of you, but I see you all and thank you for being here. So the court is going to be Hella. I'm going to play all the attorneys and two attorneys. And then Salvador is going to be the brothers Samuel. What? The brothers Samuels? You're going to be... Oh, God. Okay.
I'll be the brother.
The poo has tainted it. Yes. All right. Okay. So this is November 4th, 2019. All right. Do you want to start, Hella, with the court?
Hang on.
Where's the... I'm on page... This is page 3. Yeah, I scrolled down to page 3 because the rest is just all captions and things.
Okay. Because you haven't actually highlighted the court on mine. That's cool. All right. So, this is case number 1905-16201 and 02. People of the state of Michigan versus Dwight T. Samuels.
Okay.
And what?
Huh?
Can I give you a little direction? This is Detroit, downtown Detroit. Have a little sass, maybe a little.
She's English.
A little sass. No, it's fine. She's gonna get sassy in a bit. That's why I'm getting there.
Oh, don't worry, she'll get sassy. You have not seen this character get sassy yet.
She sounds like the queen. I've never heard the queen get sassy.
Queen. Her name is really Hyacinth Bouquet, even though it's spelled Bucket.
Bukaki?
Yes. Yeah, anyway. That's it.
All right. Okay. People of the state of Michigan versus Dwight T. Samuels and Duane T. Samuels. The matter before the court today for a final conference. Appearances, please.
Good morning, Your Honor. Patricia Bergamo. I don't know. On behalf of the people, I don't know how to say my name.
Good afternoon, Ms. Bergamo.
Jeffrey Edison on behalf of Dwight Samuels.
Good afternoon, Mr. Edison. Good afternoon to you, Mr. Samuels. You feeling better today?
Mom, yeah.
Okay. We're not going to have no problems today.
No, ma'am.
All right. Thank you. I appreciate it.
I appreciate you. Mm.
Oh, my God.
Coming on to the court.
And good afternoon to you, Mr. Samuels.
Good afternoon, Your Honor.
Good afternoon.
All right. Where do we stand? I heard a new offer.
That's correct, Your Honor. We informed Miss James this morning after both her and myself went over the guidelines for Mr. Duane Samuels. His offer is now to plead guilty to 1 count of assault with intent to murder, a felony firearms for a sentence agreement of 11 to 13 years plus 2.
Okay. Have you had a chance to talk about this with your client?
Oh,
that's still you.
They're still talking? What were you going to say, Mr. Anderson?
It should also be noted that I re-advocated a counter offer with the prosecutor's office to suggest that they reduce his minimum by 2 years.
Meaning Dwight Samuel?
For Dwight Samuels. Similarly, reduce it to 11 years, even though his guidelines may be different. And the prosecutor has declined to do that.
Okay. What's the difference? How come you're willing to drop Mr. Duane Samuel's offer by 2 years, but not Mr. Dwight's? Are their guidelines different? What's the reason?
That's correct, Your Honor. Mr. Dwight Samuel's guidelines for his PRVs, he's at 0. Now, PRVs, just so everyone knows, we have sentencing guidelines. PRVs are prior offenses, and OVs are the current charge. So they're saying that his he has no criminal history that would qualify as like a enhanced matter to raise his sentence. Whereas Mr. Dwight Samuels, for his PRVs, he is at, 30 points. So he's.
Okay. And PRV's prior record variable.
Oh, the judge explained it. Damn it. Correct. Yes, thank you.
So, am I to take that to mean that Mr. Duane Samuels has no prior criminal history, and Dwight Samuels does?
In terms of being able to score, sorry, I was pulling up the chat. The offense.
I can't see him being able to score anything. Oh, sorry.
That's you.
Because of the amount of time that has passed?
Yes. Judge, I would indicate to the court that the original scoring was based as charged. The scoring now with 0 is with scored along with the plea agreement. So
it's still AWIM.
Yes, but he would have had another charge that would have been included for prior record variable 7.
Okay.
So without that,
more felony-firearm.
felony in possession.
Okay.
Yes.
Okay. So what do you want to do, Mr. Duane Samuels? Can you raise your right hand for me? No, not like that.
Not in that direction. Didn't you learn from Elon?
I was just sending my heart out to everybody.
No.
Wrong direction.
Sorry.
Up.
Another 45 degrees. Okay.
Thank you. Dear me, we don't want to get cancelled. Okay. Do you solemnly swear or affirm that the testimony you will now give in the cause pending before this court will be the truth, the whole truth, and nothing but the truth?
Oh, yes, ma'am.
Did you just become Indian?
I thought I was black, ma'am.
Oh.
That's Salvador's impersonation of a black man in his 60s. Right.
I see. We are heading towards being cancelled any moment.
It's already happened. We're too late, as Snivell says.
You can put your hand down, please. We already have. Are you under the influence of any drugs, alcohol, or other substance that is affecting your ability to make decisions today?
Wait, hang on. I'm complete. Wait. Oh yeah, no. All right, that's the highlighted part. Sorry, I was confused. All right, go ahead, Samuels.
No, Mom.
Now, look at me. kind of funny. I'm not trying to be funny when I ask you that.
I'm incarcerated, boss. Where am I gonna get the...
I know you've been at the jail, and I would like to think that they don't have no liquor, no drugs, or anything like that over at the jail. But I have to ask everybody that question, regardless of whether they're in custody or not. So I wasn't trying to be flip or disrespectful or asking you if you're under the influence of anything. It's just a standard question I ask. I mean no harm. Okay? Now, are you under the influence of anything? Your answer is no, correct?
No, ma'am. That's like a little leading there.
Well, yeah, a little leading. It's okay. She's just trying to like get to the point.
I'm amazed that she explained.
I think so. If you remember at the beginning, there was a comment about, "Are you feeling better today, sir?" So there must have been some sort of like outburst at the last hearing. So there's some animosity, I believe, between the judge and this defendant.
So he must have made a face at her. Why is she even putting up with that shit?
I don't know. I don't know, but it gets even messier from here.
No, sir,
okay.
ma'am.
Do you understand, sir, that you stand before the court today charged with 1 count of assault with intent to murder, 1 count, which is a life offense, up to life imprisonment if you're convicted, 1 count of assault with intent to do great bodily harm less than murder, which is a 10-year offense, 1 count of firearms, possession by a felon, 1 count of carrying a concealed weapon.
Judge, as it relates to Duane Samuels, the carrying concealed weapon was dismissed at exam.
Okay, I'm sorry. Thank you for correcting me. 1 count of weapons, felony firearm, which is a mandatory 2-year period of confinement consecutive to any other time, and a felon in possession of a firearm is a 4-year offense. And I think, is it 3 felony firearm charges? Oh, yes, there's 3 count of felony firearm, and you're charged as a habitual 4th offender, which increases the possible penalty to up to life in prison. Do you understand that, you narcissist?
Yes, sir, ma'am.
Do you understand those are all the charges that are against you?
Yes, sir, ma'am.
God, are you sure you're not on something, Duane?
Are you sure? Are you sure you're okay? Now, I don't want you to think that I'm trying to threaten you or force you or intimidate you into pleading guilty. You are presumed innocent. That never changes unless and until the jury is convinced beyond an unreasonable doubt.
Yeah, unreasonable is correct.
Yes, that you are guilty and innocent. I'm just trying to make sure that you understand the charges. You understand what's being offered. The prosecutor is offering to dismiss all the other charges against you if you were to plead guilty to 1 count of assault with intent to murder and 1 count of felony firearm. Sounds good, doesn't it? With a sentence agreement of 11 to 30 plus 2, which means that in 13 years, you'll be eligible for parole and a cookie. Do you understand that?
Judge?
Oh, you can't do that, guys. You got to look this way. Okay, you got to stay facing this way. All right, Mr. Samples, you need to sit down. What's going on?
No, ma'am.
All right.
Judge, if I could just repeat the last portion where you indicated that assault with intent to murder, the felony and felony firearm.
Yes. The offer is that if you could plead guilty to one count of assault with intent to murder, one count of felony firearm, all the other counts will be dismissed against you. And there's a sentence agreement that of 11 to 30 plus 2, which means that after 13 years, you'll be eligible for parole.
I'm going to interject here real quick because there's some new people that popped in. We are reading through a transcript of a plea agreement where two twin brothers are being asked to plead guilty at the same time. And the question is this knowingly and voluntarily? So at this point, does anyone have an idea of what he's actually pleading to and what his sentence is going to be? Because it's fairly convoluted the way it's being explained. Like, I had to read through it a couple of times. So that's one of my issues. And if you spot an issue, if there's something hanky, if you think like, hey, something doesn't smell right, throw a little poop emoji in the chat, because that's what we're doing here today. And then we're going to go take a look at what the Supreme Court had to say about this and see if you were all right. 11 to 13 years.
I thought it was
I'm sorry,
13,
11 to
yeah.
30. Yeah, I'm sorry. 11
Oh, it's 11 to 30.
Yeah, 30.
Right. But
Yeah,
after
plus
13
2.
years, you'd be eligible for parole.
Yeah,
That's where the
because he
13
has
comes
2 extra years for the felon in possession, which adds on to his 11. So he gets after 13 years, he can get possibility of parole.
from. But where does the brother come in?
Can I have one moment? That was me
Yes.
reading. Oh, that's still you.
Is it? Oh, Mr. Samuels, you okay?
Yes, ma'am.
All right.
Mm-hmm.
Okay. While you're talking to him, I'm going to talk to Mr. Dwight Samuels. Mr. Samuels, can you raise your right hand? Can you?
Oh, okay. Okay. Essay.
Yes, the numbers are normal, half Irish.
Do you solemnly swear or affirm that the testimony you will now give in the cause pending before this court will be the truth, the whole truth, and nothing but the truth?
Ah, I do.
You can put your hand down. Are you under the influence of any drugs, alcohol, or any other substance that is affecting your ability to make decisions today?
No, ma'am. I'm just high on life.
You understand that you stand before the court charged with one count of assault with intent to murder, one count of assault with intent to do great bodily harm less than murder. Assault with intent to murder is a life offense. Assault with intent to do great bodily harm less than murder is a 10-year offense. One count of felon in possession of a firearm, which is a 4-year offense. One count of carrying a concealed weapon, which is a 5-year offense. And 1, 2, 3, 4 charges, counts of counts of weapons, felony firearm, one of which is charged with a second offense notice, which makes it a mandatory minimum 5 years in prison if you are convicted of that offense. And additionally, sir, you are charged as a habitual fourth offender, violent offender enhancement, which means if you are convicted, I would have no choice by law but to sentence you to a mandatory minimum of 25 years if you were convicted. Just because they filed that habitual violent offender enhancement against you. Do you understand that those are all the charges that you're facing?
Yes, ma'am.
And sir, do you understand that there is an offer that's been made to you today that you could plead guilty to one count of assault with intent to murder and one count of felony firearm? Second, that flat 5 years offense, all the other charges will be dismissed against you, and a sentence agreement of 13 to 30 plus 5, which means you'd be eligible for parole in 13 years.
18.
Sorry, 18 years.
Yes,
You
sir, ma'am.
understand that's the offer?
Yes, sir, ma'am.
All right.
Your Honor, Mr. Samuels had some questions about his prior convictions. And there is at least a review of the records reflect that there is a prior conviction for breaking and entering. Yes, in 2013, which is a high severity, which would mean that he would receive 25 points for that particular prior record variable. And if his other convictions are outside of the 10-year time frame to be counted, that 25 puts him in a category. His PRV, a D, and his offense.
So the problem is that 2013 offense is what's making his guidelines so high.
Yes, correct. Plus PRV. Oh, yeah, that's the correct. Yeah.
So is he saying that that's not him? That wasn't him, or what? What are you trying to tell me about that 2013?
No, he had raised the question about. That's you interjecting.
Why
Like
his
you talk over the attorney.
guideline
Yeah, his prior. Yeah.
were so high?
Yes. Yeah.
It's the 2013 breaking and entering with intent. That's making your guidelines so high, Mr. Samuels.
Yes, sir, ma'am.
All right, gentlemen, now I want you both to understand that I'm not trying to threaten you at all, kind of not intimidate you, harass you, or force you all to plead guilty, okay? You do not have to plead guilty. These alleged allegations are on this video. You know, they say that's you all on that video. Whatever. You can go to trial. You can. I didn't. And no one can ever hold it against you if you choose to exercise your right to go to trial. I can only bring up because, I want to make sure that you understand the sufficient, the nature of the evidence against you, and as great of the lawyers as you have.
Nature of your mind?
They're not magicians, okay? And they can only do what they can do to try to refute the evidence that's being presented. And come on now, please. And to try to present your versions of events, which, quite frankly, you don't have to do any of that. You could all just sit at the trial and play Uno if you want to, because the burden of proof is always on the prosecutor, and that never changes. But here is where we are. That's what the offer is, and it's not changing. So I need you all to let me know what you want to do. You want to take these offers, or you want to maintain your innocence and proceed to a trial?
Mr. Dwight Samuels also inquires about whether the offers were tied together. And I reiterated to him that either both of them would have to go to trial or both of them would have to plead, that they're not split up.
That's not unusual. They do that all the time. Is that your position?
Yes, Your Honor.
That's it, all or nothing.
Yes, Your Honor.
That either they both plead or they both go to trial.
That's not right. Please, boss, don't put the thing over my face. Don't put me in the dark. It's afraid of the dark, boss. Oh wait, that's Green Mile. That's John Coffey. Never mind.
Well, oftentimes in life there are things that happen that are beyond our control, like going to prison for something you didn't do, and I may not like it. You may not like it, but the prosecutors are the charging people. They're the ones that make the offer, and they make their offers the way they want to. And I can't force them to let one person plead guilty and the other go to trial. I can't force them to separate you guys. For whatever reason, they have this strategy and they want to link you together because they're assholes. Now, it could be because you guys look so much alike and they can just make one pass for you to get into prison, save paper. And they want you to both be on trial together so that, there could be no switcheroo argument in front of the jury.
Okay, so I want to stop right there. So all right, that's why I put their pictures up for the thumbnail. So the judge is implying that there's going to be some switcheroo perhaps at trial. And so if one pleads and only one goes to trial, then they could say like, oh, it wasn't me, it was my brother. While they're identical brothers, I think there's a clear distinction between them. I can't put my finger on it, but somehow I just feel like there's a difference.
I say, boss, I took the Ozempic, boss.
I mean, that's what she's saying here.
That's stupid.
Yeah. All right, it's still you, Judge. You're still pontificating.
I'm glad I chose this accent because switcheroo is quite good.
Right.
Okay, so hang on. I need to say that bit again. So that, there could be no switcheroo argument in front of the jury. That wasn't me. That was my other brother that was shooting. So maybe that's why they want you both to be tried together. So maybe that's why they want you both to be tried together. I said it twice. I don't know what their strategy is or their rationale. I'm just assuming. That's why that's probably it. But quite frankly, they do it all the time, even when it's not dealing with identical twins. Imagine that. So that's just how they roll. I can't do anything about it.
Samuels?
I say.
You're right here, man.
Yes.
For God's sake.
You have one word.
Okay, boss.
So, what you all want to do?
Go to trial, boss.
What? All right.
I don't know much about anything, Mom.
No, you clearly don't. Now you understand, Mr. Dwight Samuels. Mrs. Dwight Samuels?
Yes, boss.
If you're convicted, I'll have no choice but to give you a minimum of 25 years. At a minimum. If you're convicted as charged, do you understand that?
Yes.
No.
No.
Here, let me highlight it for you.
Thank you. Sorry, I was looking up something. No problem, boss. 18 is no different than 25. Ooh, telling the truth.
Actually, it's 30, Your Honor. 5 for the gun, plus 25.
Right. It would be a minimum of 30 years. Yeah, you're right, because your charge is a mandatory minimum 25. Yeah, it would be 30 on the minimum, because they charge you with a mandatory minimum 25, plus the felony firearm second. So it's a difference between 18 and see. Now, it might not seem like it, but 18 to 30 is different. Thank you for correcting me. That's a very important correction. Do you understand that?
Your Honor, my client, Mr. Duane, Duane Samuels, has indicated he wishes to avail himself to the offer.
Well, but you all both got to do it.
Yes, boss, we do.
All right. They got to write it up. Is it written up?
It is not yet, Your Honor.
All right.
Or the deputy. I guess I'll play the deputy too. You guys want to have a seat real quick while we have to write up the plea? Then they're talking about another case. We'll move on. He's on bond. This guy's going in and out. All right. So we're back on the record here with the court.
All right. We're back on the record. And the authors have already put on the record. And the defendants are already under oath.
Yes, your...
Mr. Dwight Samuels, can you step over so I can see your client?
Oh, sorry.
What did I ask? Mr. Samuels, I've been handed this form. It's called a settlement offer. Advice of your rights, notice of acceptance. You should have a copy of it in front of you in pink.
Yes.
Dolly, you could just pay attention.
Somewhat, yes, boss.
We haven't had to that part yet.
Well,
No.
Then I said yes.
Yeah.
I said yes.
I know, it's just how David keeps highlighting your piece.
Oh. Okay, so I was right. Okay.
Is that your signature at the very bottom of the form?
Somewhat, yes, boss.
But you read it and understood?
Yes, boss.
Well, what do you mean by somewhat?
I mean, boss.
You couldn't sign as good as you
Right, boss.
normally would?
Right, boss. Mm-hmm.
Is that your attorney's signature above yours?
Yes, boss. Mm-hmm.
Am I to take that to mean that that he went over this form with you?
Yes, sir.
Did you read it and understand it before you signed it?
Yes, sir, boss. Man.
And Mr. Duane Samuels, same question to you, sir. I've been handed the form called Settlement Offer, Advice of Rights, Notice of Acceptance. Is that your signature at the very bottom of the form?
Oh, yes, ma'am.
Do you have a copy of it in front of you, in pink?
Oh, yes, ma'am.
And I see your attorney's signature appears above yours. Am I to take that to mean that she went over the form with you before you signed it?
Oh, that's correct, ma'am.
And you read it and understood it before you signed it?
Of course, ma'am.
Gentlemen, do you both understand that by signing this form, you're indicating to me that you wish to plead guilty? Are you feeling okay?
Sorry, Mom.
Okay. To assault with intent to murder, which a life offense and weapons, felony firearm, and that when you plead guilty, you waive all the rights that would be afforded to you both before, during, and after the trial of any kind. Do you understand that, Mr. Samuels, Duane Samuels, Dwight Samuels?
Yes, Mom.
Hey, welcome, Luke. So, yeah, we've already run across a few issues. These are two twin brothers.
Apart from me.
Yeah, these are two twin brothers being forced to plead together and either they both plea or they both go to trial, even though one wanted to accept the plea and the other one wanted to go to trial. And the judge is like, no, it's both of you or none of you. So now we're getting into sort of the factual issues of the case. And you can see why, in addition to like plead or your brother doesn't get this deal issue, we have we have a whole bunch of other factual issues here. So that's what we're getting into now.
Did we just have a Sean raid?
Did we?
I think so.
Oh,
Hey,
if we
guys.
did, awesome. Thank you. Oh, yeah. Hey, guys. Welcome. Well, for everybody coming in, what we are doing is we're reading through a plea agreement that took place in 2019 between two identical twin brothers. Now, the plea offer from the state is that they both plead guilty to lesser included charges, or they both go to trial. There's no separation. Now, the one brother is wanted to take the case to trial. The other one wanted to accept the deal, but the court wouldn't allow them to do that and basically said, we have all the evidence right here on this video, so you should probably plead, but I'm not coercing you. And if you don't plead, then your brother's not getting the sweetheart deal, and he's going to go away for life. And the judge pontificated that the reason why the prosecutor wanted the two brothers to plead together is because they're identical twins. And if one went to trial and the other one pled out, then the one that's in trial could say, it wasn't me, it was my brother. But I feel like they look a little different. I feel like the switcheroo might not have worked as well as the judge was thinking or suggesting. So the issues here we're trying to spot is this a knowing plea? Did they knowingly plead to this offer? And did they voluntarily do it? And the chat's throwing poop emojis in anytime they hear something extremely sus. So, yeah, they're identical twins. They each have half rights. Yeah, exactly. So.
And the judge even referred to the word switcheroo. You know, like
she literally said switcheroo.
Yeah, going to trial and pulling a switcheroo.
Yeah, it's not a 80s buddy movie.
Yeah.
Also, I'm trying to do my Hyacinth bouquet for anyone who knows who Hyacinth is.
Hey, man. 3/5 actually.
So Hella is reading for the judge.
It's 3
Salvador is reading for both brothers since they're twins, obviously identical twins, as we've already addressed. And I am reading for everyone else, basically the attorneys and sometimes the court staff. So that's what we're doing. We're going through this. And so if you hear something really like shady, like I don't think that's right, whether or not it's an addressing of the knowingly aspect or the coercive aspect, go ahead and throw a little poop emoji in the chat. And then we're going to take a look at this, what the Supreme Court had to say about this and whether or not it was knowingly and voluntarily entered into.
Also, I think that Darlene might be watching baseball.
Yeah, I think
I'm
definitely.
No.
I keep having to highlight his.
Oh, it's my turn again. I'm sorry. Well, it doesn't come up.
It's
that
not
much.
your turn, actually. I'm just pre-highlighting them for you. It's actually we're right here.
Safa.
You know, I'm fine, thanks.
Well,
I haven't missed one. Anyway, do you understand that, Mr. Duane Samuels?
Yes, ma'am.
Mr. Dwight Samuels, do you also understand, sir, that you're pleading guilty to felony firearm as a second offense notice, which carries with it a mandatory term of incarceration of 5 years consecutive to any time that you serve for the assault with intent to murder that offense?
Yes, ma'am.
And Mr. Duane Samuels, do you understand?
By the way, I just want to explain. Hang on, I'm sorry. So this felony firearm, what this charge is, it'll be important in a minute. What this charge is a felon, a prior felon in possession of a firearm. That's what this charge is. So it's a mandatory minimum 5 years because he's a felon and he's pleading guilty to be in possession of a firearm. All right. So sorry. Go ahead.
And Ariel, she didn't explain what rights were being waived, did she?
No, she did not. She did
really.
not explain.
She just said your rights.
Yeah, she said your rights. Now she did refer to the pink form. Remember the pink form that she talked about? Now that does lay out your rights to call witnesses and confront witnesses and have an attorney, and it does spell that out, and he signed it, but she didn't put it on the record.
Not true.
Yeah.
Sorry, where are we?
I think it's Dwight Samuels. Oh, no, I'm sorry. We were on this paragraph and I stopped you. I don't remember where you left off, though.
Oh, I got to the end of it.
Oh, okay, so then we're waiting on Sal, as usual.
Yes, sir, boss.
And Mr. Duane Samuels, do you understand that you're pleading guilty to weapons, a felony firearm, which is a flat 2 years and has to be served consecutive to any time that you would serve for the assault with intent to murder?
Yes, I reckon. Mm-hmm.
And gentlemen, do you both understand that in exchange for a guilty plea to those 2 offenses, the prosecutor has agreed to dismiss all the other charges against you? Do you understand that, Mr. Dwight Samuels?
Yes, sir. Yes, boss, ma'am.
Do you also understand that they've agreed to withdraw the habitual violent offender enhancement, which would have increased that maximum minimum, which would have set a mandatory scroll.
Sorry, I was responding to Luke. I do have the advice of rights form. I'll pull it up in a minute.
Mandatory minimum offense if you were convicted to 25 years. You understand that?
Yes, sir, boss.
They're dismissing that. And Mr. Dwight Samuels, do you also understand that you're agreeing to serve 13 to 30 years in the Michigan Department of Corrections for the assault with intent to murder, plus 5 years for the felony firearm second?
Yes, sir, ma'am.
And Mr. Duane Samuels, do you understand that they've agreed to dismiss all the other charges against you?
Yes, I reckon.
And that you've agreed to serve 11, because you didn't get this before. 11 to 30 years plus 2.
I'll take a biggins. Yes.
For the felony firearm. You understand that?
Yes, ma'am, I reckon.
All right. Gentlemen, I'd like to direct your attention to June 19th, 2019. Were you both at 1544? I used to work there. West 7 Mile Road in the city of Detroit. Did you go to that area, Mr. Dwight Samuels?
Yes, sir, boss, man.
Hang on, before we get into the facts, let me just pull up the advice of rights form. So, because people are asking about it. Right. So this is the advice of rights form here. So this is what you sign. So this is Michigan advice of rights plea information. So you put the case number in there. If you require accommodation, you use this form because of disabilities you have been brought to this court on. Oh, this is for a misdemeanor, but it's the exact same form for felony. Let's pull that up real quick. To plead guilty, not guilty, to stand mute. You have the right to an attorney appointed at public expense if you're indigent. You may have to repay the expenses of the appointed attorney. If you have a trial, you have the following rights: call witnesses, to see, hear, and question witnesses against you. If you plead guilty or no contest to the plea, plea is accepted, you will not have the right to trial of any kind. So this is the form here, and then at the bottom, you sign it and fill out your information, indicating that you received this information, that you went over it with your attorney, and that you're satisfied and you're freely giving up your rights. So it does list out your rights here, and that's the document that they were referring to.
So that's the pink form.
That's the pink form. Yeah. In the courts, they have a variety of. They have like those carbon paper forms, so you write on the top sheet and it goes all the way through, and the pink one is for the defendant. Okay. So were you there, Samuels?
Yes, sir, boss.
Okay.
You know what we could do? We could just take a little sound clip of him and just.
I know, right?
And did you go to that area, Mr. Duane Samuels?
All right, hang on. We have one other question. Someone wanted to know which defendant was which, and
I reckon.
Yeah, I don't even know. Go.
Yeah, so I'm gonna wait, hang on. Where were we? Fuck.
We were at 25 before.
25. Okay, so we're at page 25. Let me scroll back up. See which one, because I lost track and now I forget because they're so identical.
Yeah, that's why.
Well, no. One was in the
No,
Green
right.
Mile, the other was in Sling Blade.
Let's see here. Let's see. Y'all could sit at trial and play Uno. Hang on. So that was before that. Oh yeah, it's just like you could all just sit there and play Uno. I don't care. It's all on the video, and you're gonna get convicted. That's
That
essentially
was
what the judge said.
nuts. You guys missed that bit.
Did she
Yeah.
actually say Uno?
She
Yeah.
said Uno.
Oh, I
You
thought you
said
ad libbed that.
No,
like,
that's
no,
actually.
I
in
was
the
looking to
transcript.
see it. I didn't see that. I was looking.
Let's see here. Mr. Samuels, let's see, has a question about this.
like
PRVs, they're talking about his priors and how that would add up. Let's see here. His prior, yeah, like you can all plead guilty or you can all go to trial. Yeah, here's what she says, like you can just sit there and play Uno, I think.
We should read that bit again for everyone who's not new here.
So Dwight Samuels was the one that was questioning about whether or not they were tied together. And then this is where the judge says you both plead guilty or you both go to trial.
I see.
And Dwight says that's not right. And I think it's so it's
right,
Dwight,
boss, man.
Dwight that wants to go to trial, and Duane wants to accept it.
Okay, so
I reckon.
Dwayne's guilty.
Yeah. So Dwight wants to go to trial, and Duane wants to accept the plea.
Duane.
Right.
Okay, so Duane, yes, ma'am. So this is Duane, yes, ma'am. I understand that. He's the one that wants to accept the plea. It's Dwight that wants to go to trial.
Yes,
Yeah.
ma'am, I reckon. Mhm.
Hang on. Where are you? Because I don't think he says reckon.
No, he doesn't.
Oh, there, right,
Oh,
okay.
there, yeah.
And was there a business like a Coney Island restaurant or something that was at that address?
I reckon.
Oh
Mhm.
God. In the city of Detroit.
Mhm.
You agree?
Mhm. I reckon.
And gentlemen, when you went there, did you come into contact both come into contact with a guy whose name you know now is Keith Fly?
Yes, I reckon. I don't know him, boss man.
You didn't know his name at the time, but
No, I boss.
that's not what he says.
It's now I.
Now I.
There you go. There you go. We can read.
Yeah.
Yes, boss. Oh no.
No, okay. You understand that's his name, Keith Fly?
Yes, boss.
You understand that, Mr. Samuel?
Mm-hmm. I reckon. This isn't easy.
And gentlemen, when you came into contact with Mr. Keith Fly, is it true that there was a fight that ensued?
There were several guys, boss, ma'am. Not just one.
Yeah, but let's just talk about the Keith guy, the guy that got shot.
Yes, I reckon.
Let's just talk about him. Was there a fight that involved a guy?
Yes, boss.
And his name, now you know, is Keith, okay? You agree with me?
Yes, boss, ma'am.
Now, when the fight began, is it true that when you both went to that Coney Island, who had the gun? Who had the gun? Which one of you had the gun?
I did, Dwight.
Hang on. So Dwight is the one
Dwight says,
who...
I did, Dwight. So Dwight had the gun.
Okay. And is it true, Mr. Duane Samuels, that you knew your brother was armed with a gun? Isn't that true?
Judge, can I ask the questions in a different fashion?
Well, no, because It's a way around it. Is it true, Mr. Dwight Samuels, that you were armed with a gun?
Yes, boss, ma'am.
And is it true that you fired that gun and Mr. Keith's fly got shot?
Yes, ma'am.
And when you shot that gun, you intended, when you fired the gun, you intended to shoot him. Is that true?
Not somewhat, but yes.
Well, is it
Okay, yes, boss, ma'am.
you intended to shoot him?
Yes, boss, ma'am.
And
No,
you
the
know
answer is okay. Damn it, Sal.
and you know when you shoot somebody with a gun that you can kill them. Is that true?
Yes.
And when you shoot a gun at a man at close range, you know that you can kill somebody. Is that true?
Yes.
And you did it anyway, knowing that he could be killed.
Yes, ma'am, boss.
When you shot him. No, Mr. Duane Samuels, you had a metal pipe. Is that true?
Mm-hmm. I had a stick, yes.
And what was it made out of?
Sling blade. Oh no, a black tape. It had a little metal filling to it, yes, sir.
All right, and you used that stick in order to fight Keith Fly. Is that true?
That's correct, I reckon.
And you beat him about his head and his body using that stick. Is that true?
Yes, ma'am.
Now, how old are you?
61 years of age.
Now, you know, at 61 years old, you know that you beat somebody with a hard stick, that you can cause blunt force trauma and it can kill them. You could kill somebody when you beat them with a stick. Did you know that?
I reckon, yes, ma'am.
And you know that the decision to beat that man using that stick, knowing good and well that it could kill him.
That was not my intent, but...
Well, you got to either, there's two questions. Either you knew your brother had a gun and your brother was going to shoot somebody with that gun, or either you could beat the man with a stick, knowing that the stick could kill him, and you did it anyway. Or the third choice is you're not pleading guilty.
Remember the poop emojis?
Your brother had a gun. Boss.
No, he got to say it for himself. You got to say it for himself. He got to be.
So Duane is answering the questions, or supposed to be, and Dwight pops up. Your brother had a gun. So Dwight's telling Duane to say your brother had a gun. And then the court's chiming in. No, he's got to answer for himself. So that's where we are. Now it's Duane.
Okay. I hit him with a stick, I reckon.
I love how both of them are both comatose.
Are what?
They're comatose. They're hardly alive, either of them.
I know.
Well, they're the only two characters from prison movies I can think of.
Oh my God.
Okay.
Right here.
You hit him with a stick?
Yeah, I reckon.
Knowing it could kill him? You narcissist.
That's correct.
And you made a conscious decision to beat him with that stick, knowing good and well that could have killed him. Is that true?
It's a possibility, yes, ma'am.
All right. Ms. Bajamo, are you satisfied with the factual basis?
Well, as the prosecutor, and I just want this case to be over with, yes, I'm satisfied, Your Honor.
Well, the other is the felony firearm, though. We're going to talk about that.
Oh,
Did you know that your brother had a gun? At some point, did you tell my brother to bring the gun because that's what you said you did? And in order to be guilty of felony firearm, you had to know when a felony was being committed with a gun.
That was never proven.
he says that was never proven.
Yeah, but well, nothing being proven because you're pleading guilty. They don't have to prove.
Yeah.
Exactly. So.
If you plead guilty.
Why would I say that I reckon I knew when I didn't know?
Well,
Judge, can I ask a question?
No. Sorry. Yeah, sure. Ask him the question.
So remember the judge, first of all, said that he couldn't ask the questions the way he wanted to. She was going to do it. She obviously failed. So now he's going to step in. Mr. Duane Samuels, you were present when your brother shot Keith Fly. Is that correct?
That's correct, I reckon.
After Miss Fly or Mr. Fly was shot, did you continue to hit and stomp him before the two of you left out of the restaurant?
No, I reckon.
Did you hit or stomp him afterwards?
No.
Let me ask you another question. Now, you understand that you're a convicted felon.
Yes, ma'am, I reckon.
And as a convicted felon, you can't be around guns.
That's correct.
You can't be around anybody that you know has a gun. And you can't have reasonable access to any gun. Is that true?
That's correct, I reckon.
So you were standing right there when your brother shot Mr. Keith Fly with that gun.
Yes, ma'am, I reckon.
You got to switch to Dwight mode now.
He didn't know I had it.
You should have done Dwight Schrute from The Office for Dwight. I'm just thinking about that now.
Wait, god damn it. Dwight. God damn, this is getting hard right now.
All right, the court.
Hold on. Just wait.
Let's finish this out, I reckon.
Can you please let me do my whole job? Please, Mr. Samuels. You were standing right there when your brother shot Mr. Fly, correct?
Yes, ma'am, I reckon.
And how did you all get there that day to Coney Island? How did you all get there?
I drove.
In a car?
Yes, ma'am, I reckon.
With who?
My brother.
All right. And after your brother shot Mr. Fly, did you all leave together?
That's correct, I reckon.
In the same car?
Yes, ma'am.
And at that point, you knew your brother had a gun because you just saw him shoot somebody.
That's correct, I reckon.
Would that be true?
Yes, ma'am.
And at that point, you knew that a gun was present, correct? Because you had just saw him.
At that point,
use it.
Yes, ma'am. Wait. Yes, ma'am.
And that makes you a felon in possession of a firearm because you know a gun's there and you had reasonable access to it. Would that be true? Now, you're not pleading guilty to felon in possession of firearm because the prosecutor has agreed to dismiss that charge against you.
Okay.
As an exchange for the plea.
Yeah, that's true.
But I'm trying to get to the factual basis for the felony firearm, okay? So at that point, you're in the car with your brother with a gun, correct?
Oh, see, so this is so convoluted that I was even mixed up. So the judge is trying to sentence him to committing a felony while in possession of a firearm, not being a past felon in possession of a firearm. So trying to convince, they're trying to get statements of fact out here that Duane was committing a felony while in the possession of a firearm, but his brother had the firearm. His brother used the firearm. And after his brother used the firearm, he stopped the felonious assault. So he's not actually committing a felony while in possession. He didn't have possession. Even if you want to argue constructive possession, meaning like he had access to the gun, he wasn't committing a felony at that point. Once he realized that he had access to a gun, the felony was done. So that's the problem that this judge is having.
Correct?
I think
yes,
Luke's got it right. What you mean to say is shit, shit, shit. Yeah, this whole thing's a shit show.
Yeah.
Sorry, where are we, guys?
There. Down the bottom.
Okay,
yes, ma'am.
And you had reasonable access to it.
I reckon, yes, ma'am.
Are you satisfied with that as a factual basis for him being for felony firearm? Because it's felon in possession, felony firearm, the gun's there, he knows it's there.
Satisfied.
Ms. Bijamo?
Yes, Your Honor.
Now I need to ask you another question, Mr. Dwight Samuels.
Yes, boss, ma'am.
Is it true, sir, that you had been previously convicted of felony firearm, that on or about October 28th, 2002, you were convicted of the offense of felony firearm in the Third Circuit Court?
I was tired, boss. I was convicted, boss.
All right. So this is the second time that you have.
But did they also tell you I didn't have the gun? The guy had the gun, brought it into the fist fight, and didn't know how to use it.
What are you talking about? Back in 2002?
Yes, boss.
No. They didn't tell me all that.
Oh, okay, boss.
I just need to know, were you convicted of it back in 2002?
I love these defendants that want to relitigate their old convictions. It happens all the time, by the way. They're like, but I wasn't guilty. I just pled guilty. That means you have a conviction.
Didn't they tell you about
it? No.
Yes, sir. They found me.
Okay.
Yes, sir.
And so this is the second time. Could you scroll up, please?
Oh, sorry. I was trying to interact with chat, be a good streamer.
I know.
Second time
that you have been accused of having a gun used during a felony. You agree with that?
There was a gun used, yes, sir.
All right.
It was not my gun, boss. It was his gun.
Back in 2002?
Yes, sir.
No, we're not talking about 2019 when you're at Coney Island, though.
Okay.
God. Is this the second time that you've been accused of having a weapon?
Yes, sir.
a handgun used in a felony.
Yes.
All right. Yes, Miss Pajamo?
Your Honor, since we made a factual basis out for a felony in possession, I would suggest maybe amending the plea form to reflect count 8, which is the felony firearm for a felon in possession.
Oh, as opposed to count 6?
Yes.
All right. You all need to make that...
One of the defendants.
Yes. What's the difference?
It's not really a difference, but it's just probably it's a difference, or you can amend the information. I mean, I don't think it really matters.
I don't know that it makes a difference, but it doesn't matter. That's what the attorney says. I'm fine either way. That's what the defense attorney says. We're just going to amend this halfway through the plea agreement that they all just took the pleas on.
Wow, what is the difference?
Technically, I don't think it matters for sentencing, and I think that's what he's trying to say. It doesn't matter for sentencing, but the charge is different. So committing a felon or a felony with a firearm, or being a past felon in possession of a firearm, I think the sentencing would have been the same, and that's why they're saying it doesn't matter. But it is a very distinct, different charge.
It sounds different.
It is different.
Yeah.
So I think they're creating a situation where they're just trying to get through this, because they couldn't get him to plea to being committing a felony with possession of a firearm, but they can constructively.
That's what DB was saying.
Yeah, they can constructively say he was in. Well, it's a legal fiction. They could say that he's in constructive possession of the firearm, being a felon. So that's, I think, what they're trying to amend it to. But they're doing this this is page 37 of a 40-page transcript. Obviously, because we only have 3 pages left, they don't go back through the whole plea thing again, right?
No.
So my last statement is I'm fine either way.
Okay. Yeah, okay. So, Mr. Duane Samuels, count 6 is the one that is going to be dismissed, and count 8 is the one that he pled to.
Thank you.
All right, I've noted that. Are you satisfied with the factual basis as it relates to your client, Mr. Edison?
Notice they didn't go back to the defendants to have them say anything under oath, like, yes, I agree to this change. The attorney is like, yeah, I'm good with that. Yes, that's my answer.
Are you satisfied with the factual basis as it relates to your client, Miss James?
Yes, Your Honor.
Are either of you aware of any threats, promises, tricks, or inducements that have not been disclosed on the record that have caused these defendants to plead guilty today? Ms. Pajamo?
They have been not disclosed on the record? No, but there's been plenty disclosed
they're all
on the record.
Yeah.
How about trying to convince both brothers? One is clearly not guilty of possessing a firearm while committing a felony, to plead to that so that the other brother doesn't spend life in prison. How about that one? But that was on the record, Judge. So
we just read that.
No, we're good.
Yeah. Oh dear.
I don't even know where we are. Miss James?
Mr. Edison? That's you.
I just keep saying, Mr. Edison, no. And then no, Your Honor. I just keep saying no. We're good.
Yeah.
We have nothing off the record.
Are you both, all three of you, satisfied that I have complied with the court rules regarding guilty pleas?
Yes, Your Honor. Yes, Your Honor. Yes.
Gentlemen, I find that the guilty plea that you made today have been freely, knowingly, and voluntarily done, and find that the factual bases that have been placed on this record are sufficient to find you guilty of assault with intent to murder and weapons felony firearm and the secondary offense noted for Dwight Samuels and a first felony firearm offense for Duane Samuels. I'll accept your guilty plea to these offenses, and these matters will be set for sentence set to occur on who wants to be the clerk?
November 18th.
Oh, sorry.
Dang.
I'm sorry. I was confused as to
Dang.
why you stopped. November
putting
18th, Your Honor. November 18th is our sentencing date for these two
We're
gentlemen.
putting everything on November 18th. I'm getting my feet manicured that day. Anyway, I'll see you back on November 18th. That concludes this matter.
Thank you, ma'am, I reckon. Thank you, boss, ma'am. Have a nice day.
You know, side by side, I noticed a difference between Salvador's takes on both these Samuels.
Really?
Okay, so that is the end of it. All right, so to recap, what we have here are two identical twin brothers, identical twin brothers who could play switcheroo in a trial. So the prosecutor wants them to plead together, or they both go to trial. One, I don't think Duane is guilty. I mean, he's guilty of beating the guy with the stick with tape on it, but not the felony firearm. But he pleads. He wants to take the plea so that his brother doesn't spend life in prison. His brother Dwight, wants to go to trial. And so the question is this a knowing and voluntary plea? Do they know what the consequences are? Do they know what rights they're giving up? And have they been coerced in any way, or is it completely voluntary? So that's my question. Everyone, we announced at the beginning, put the little poop emojis in the chat when you hear something sus come up in this reading. There was a whole lot of sus, right?
It was ridiculous.
It was ridiculous, but this is very common. Unfortunately, these type of plea agreements where you all plea or you all go to trial. The problem is that we have two twin brothers in the court, at the same time looking across at each other and be like, well, if I don't take a plea to something that I'm fairly confident I didn't do, and I can't even establish a factual basis for it, for the plea, then my brother's going to spend life in prison. The question that was posed to the Michigan Supreme Court was, is that coercive? Smells too much like shit. So where do you guys think the Supreme Court came down on this? Now, mind you, this was in 2019. There was an opinion issued by the Michigan Supreme Court in July of 2024. Yeah. And the fact that it was amended last minute without getting the defendants involved at all. I mean, there was no question of the defendants. Like, are you guys good with this? The attorneys just said, yeah, let's just get this done with and be done with this. So that pink sheet that we talked about, that was signed before they amended.
Yeah.
Ooh.
So they amend the plea after the signature.
Ooh.
Now it's done on the record, but I mean, I don't know. So November 18th comes around. That's the date for sentencing. And Mr. Dwight Samuels wants to set aside his plea.
Set aside. What do you mean by set aside?
He wants to withdraw his plea. He wants to say,
Okay.
you know what? I'm not going to plea. I'm going to make sure I'm going to read this and make sure that it was Dwight. Let's see here.
Should have been Dwight. He's the one we
Yeah.
think's not guilty.
Yeah. No, Duane is the one we think is not guilty. Dwight is the one that wanted the trial. Duane pled to something I don't think he's guilty of in order to save his brother life in prison if they were convicted.
I reckon.
Okay. So, I apologize. Nope, it was Duane that wanted to set aside.
Yes,
Let's see.
boss, man.
Here, let's just go through this. All right, so this is the summary. So this is the Court of Appeals, or this is the Supreme Court's opinion.
I thought it was Dwight.
Yeah. So Dwight Samuels is the one that appeals this. He was charged in Wayne County Circuit Court. Fourth offense, habitual offender. We can go through all the charges we just did. Defendant's identical twin brother, Dwayne, was similarly charged The charges resulted from a fight the defendant and his twin brother were involved in at the restaurant. The prosecution offered the brothers a package deal offer under which each of them would plead guilty to assault with intent to murder and 1 count of felony firearms in exchange for the remaining charges being dismissed. However, the offer was contingent upon both brothers accepting the plea offer. At the plea hearing, the defendant, so Dwight, initially objected to the package deal offer. Remember, and Duane was the one that accepted.
Did they actually call it a package deal?
Yeah, they call it a package deal plea offer. That's what it's called. That was the
What,
original.
like buy one get one free?
Yeah, it's a package deal plea offer. That's the term of art. Package deal plea offer. Stating that it was not right. And when the trial court asked how the defendant wanted to proceed, the defendant stated that he wanted to go to trial. However, after his twin brother's trial counsel indicated that his brother wished to plead guilty, defendant changed his plea and informed the trial court that he wished to plead guilty. The defendant and his twin brother both pled in accordance with the package deal offer, and the trial court accepted the pleas. Neither brother raised an issue of voluntariness during the plea colloquy. That's what we just read, right? They didn't raise that issue with the transcripts that we just read. At sentencing, both the defendant and his twin brother moved to withdraw their pleas, arguing that they were involuntary because the conditional format of the package deal offer was coercive and had left them with no choice but to plead guilty. Without first holding an evidentiary hearing, the court, Judge Lillard, denied the motion, reasoning that the pleas had been entered into freely, knowingly, and voluntarily. The trial court then sentenced the defendants according to the plea offer. So they got the 13 and 30 and the 15 and 30. Defendant sought leave to appeal with the Court of Appeals. That was denied. Then he appealed to the Supreme Court. The Supreme Court sent it back down to the Court of Appeals and said, you guys handle this for a little bit. Let us know how that goes. And they said that the Court of Appeals is to consider the following issues. 1, whether the trial court is required to hold an evidentiary hearing on the voluntariness of a guilty plea that is induced in part by an offer of leniency to a relative, and if, how the trial court is to determine whether an offer of leniency to a relative rendered the defendant's plea involuntary in fact. So the court has to decide whether or not just the mere package deal plea of a relative is coercive, and if so, did it in fact coerce this particular defendant? That's what the Court of Appeals is supposed to decide. On remand, the Court of Appeals, and it gives the names of the justices, affirmed the trial court's denial of the defendant's motion to withhold the plea without an evidentiary hearing. In reaching its conclusion, the Court of Appeals held that the trial court determines the voluntariness of the guilty plea induced by the promise of leniency to a relative or any other third party by assessing whether the prosecution had probable cause to prosecute the third party at the time of the defendant's guilty plea. So what they're saying is that so long as the prosecutor had enough evidence to prosecute Duane, then Dwight's plea was voluntary, which seems odd. That's what they're saying. As long as there's probable cause to charge the brother, then the other brother's plea is voluntary.
Huh?
That's
Why
what the Court
are
of
they
Appeals said.
connected?
The defendant sought leave to appeal to the Supreme Court, and the Supreme Court took it up. So this isn't the opinion. This is just the syllabus. The opinion's down below, and I can throw it in my Discord. Actually, I think both of them are already in there. In the opinion, Justice Bernstein of that Bernstein, if you're from the Detroit area, you know, joined in the opinion. In a package deal offer, the prosecutor requires multiple defendants to agree to the plea offer for any single defendant to receive the benefit of the plea. When the defendant seeks to withdraw his plea on the basis that it is involuntary, and the record raises a question of fact about the voluntariness of the plea that was made in accordance with the package deal plea offer on multiple defendants, the trial court must hold an evidentiary hearing to determine whether the defendant's plea was involuntary. So that's the court's decision in a nutshell. So they're not saying that package deal pleas, even with siblings or relatives, are unlawful and you can't do them. They're saying you can do them.
Yeah.
They're completely fine. You don't have to have an evidentiary hearing beforehand. You don't have to separate the parties beforehand. But if one of them raises an issue after the plea, then go ahead and hold an evidentiary hearing. So package deals are still lawful in Michigan. And they can be against relatives, even when you're getting extremely lenient deals for one or the other. And so long as the defendant after the plea, not before or during the plea, but after the plea raises an issue, then you have an evidentiary hearing to determine whether or not it's voluntary. That was the court's decision.
So did they get an evidentiary hearing after?
Yeah, they held an evidentiary hearing, and both the gentlemen are serving the exact same sentences as they were. I don't know what the court determined, but I think they ended up doing a resentencing for Dwight, because Duane didn't appeal. Duane was just like, all right, I'm going to do my 15 and call it. But Dwight appealed, and he was resentenced, and I think he got the same deal, or the same thing.
So when you say that Dwight appealed, was my question is saying,
so he appealed saying that his plea was not voluntary and therefore it should be set aside, and also argued that it was coercive to do these package deals. That was the appeal. It's coercive in its nature to do these package deals, and and because of that, my plea wasn't voluntary. You should set my plea aside. Let me go to trial. Or
he wanted to go to trial.
He wanted to go to trial without his brother. He wanted to go to trial to try to get off. But he didn't want to be coerced into taking a plea, because otherwise his brother, who didn't really do the things that the prosecutor was saying they did, would be potentially have to go to trial and get convicted for life. So the issue here is really, was it coercive? And I think it was highly coercive. I mean, reading through that thing,
absolutely,
I think the whole process was coercive. And the court said, yeah, it's fine. Everything you did was fine, Judge, except if he raises it at sentencing, like after the fact, then you got to hold an evidentiary hearing. But everything else is fine. Like the Supreme Court. Now, I don't know exactly what the issues that were raised. I'm not looking at the appellate brief. I'm just looking at that transcript and the opinion. And while I like the idea, like, hey, if a defendant raises an objection to the voluntariness, you have to have an evidentiary hearing. I love that idea. But why do we have these package deals in the first place? And why should it be okay for the judge to say, I've got all the evidence right here on this video that you're guilty as hell, so you might as well plea?
That part was the worst.
Yeah,
right?
yeah.
She was like, well, your lawyers, they're not magicians.
Oh, yeah, she said that too. Yeah, if you guys came in late, you missed a ton of really good stuff. Like, your lawyers aren't magicians. Everything was captured on video. It's right here. You guys can sit and play Uno all day long during the trial, and there's nothing you can do about it. You're going to get convicted, and I'm going to be forced to sentence you to 25 to life, which means that plus an extra 5 for you, Mr. Duane. That's what he was looking at. He was looking at 30 to life. That's why Dwight wanted to plead. His brother, who wasn't even guilty of the offenses that they alleged, maybe assault with intent to murder or do great bodily harm. That's what it was. Assault with intent to do great bodily harm. Maybe that, because he was hitting him with a metal pipe covered in tape. But
does the tape matter?
It's softer. He can argue at trial potentially that he didn't intend to unalive him because he was hitting him with a soft tape.
I mean,
metal
is it
thing
common to put tape on it to do less harm?
It's common to do that so it doesn't look like a big metal pipe.
Or does it lessen the sound?
It might lessen the sound. I don't know why they do it. They do it a lot. Maybe it's grip. I have no idea. I'm not into the thug life.
Really?
So I just don't know. You. Better grip, yeah.
Okay,
yeah, maybe.
But then
grip.
You could also argue that you were trying to lessen the damage a little bit.
Yeah, that's what my thought would be. But I mean, so that's what Duane is guilty of, right? But he pleads to felony firearm, and he pleads to assault with intent to murder, and 1 count of felony firearm. I mean, that doesn't seem like that's what he's guilty of once they start going through the factual things. But hey, it's all on video, and your attorneys aren't magicians. They can question some people, but you're going to be found guilty. So you get an additional 5 years in prison. That's 30 years to life.
It's like a game show.
Yeah.
Dun, dun, dun.
But none of that, all of that is fine, according to the Court of Appeals, and according to the Supreme Court. All of that is fine. And the package deal plea agreements is absolutely fine too. You just, if they raise an issue, give them an evidentiary hearing. Give them an.
Isn't it unconstitutional to have your right to due process dependent on somebody else's right to due process?
I mean,
yeah, I mean, okay, so here's like the sort of theoretical underpinnings of all of this, right? The prosecutor brings charges, presumably ones that they know that they can convict you of. You have a right to trial and have 12 people judge you and say you're guilty or not guilty, right? So we start with that premise. Now, if the prosecutor wants to make a deal and say, tell you what, I know I have enough to convict you of this because that's why I brought the charges, but I'll let you plead to something lesser. Prosecutor is free to do that. As the judge said, prosecutor is free to do that. The question is really then, can you say, hey, if this person pleads, then I will reduce your charge? And that's the fundamental question that we're really getting at. Like, if this person pleads, then I'll reduce your charge and offer a plea. I feel like under the idea that a prosecutor brings the charges, they can, but I don't like it. It's happening with my lighting. I got to get shades, Valhalla. I got the sun shining in behind me. The trees haven't filled in with their leaves yet, and it's that time of year, the sun's shining in.
It seems like it's not in the spirit of the Constitution.
Right? That's my thought.
Yeah.
There we go.
Like, every person has the same set of rights. It shouldn't be dependent on somebody else.
I feel the same. I feel like if you are a defendant, then your case should be pled or not pled and gone to trial based on those decisions outside of any other influence. That's why I don't like this package deal plea offer, especially when it involves family. But Michigan Supreme Court said it's fine.
I guess it's kind of similar to going to trial with like co-defendants, like when a trial's not bifurcated, so you don't get your own day in court. You're being prosecuted with your co-defendant.
Yeah. So in reality, Half Irish, I believe the attorneys knew their guys were going to get convicted and thought that the sentence in the plea agreement was the best for them. It didn't really care how the court worked it out, so long as the sentence was the same. We do these legal fictions all the time, like misdemeanor stuff. But if you drive on a suspended license, the consequences are way worse than allowing an unlicensed driver to operate your vehicle. That's still a crime, but the consequences are way less. Like, there's no jail time. It doesn't hit your driver's license. The fines are less. So we come up with this legal constructive theory that we plea it down to Salvador doesn't have a driver's license. He's driving around and he gets picked up. Well, Salvador allowed an unlicensed driver that also happened to be Salvador to operate his vehicle, right? And we create these legal fictions and we plead down to these things. And for us as attorneys, we don't care what, that it makes no sense logically that we allowed ourselves to drive. It's silly, right? So long as the sentence is what we want for our client. That might have been what's going on with these attorneys. Yeah. But I don't know. I'm not in their head. So, but yeah, I think each individual defendant should be treated separately. And I think it's unfair to put that pressure on Dwight. He clearly wanted to go to trial. Then let him have his trial. Duane clearly wanted to plea. Let him plea. I don't think
Yeah.
Duane should have pled. I think Duane had a likelihood. And then there's the issue of bifurcating the trials. Like, would they have been tried together like you were talking about, or would they have been separate? I don't know anything about that, what the game plan was there. But where's Babu?
Trying to get him.
I see your finger tapping. Get his attention. But anyway, so I'm gonna start doing these indigent criminal appellate cases. And so this came across my table on Tuesday, I think. I was like, I got to stream about this because this was just insane. It was an insane hearing with all kinds of shenanigans and unlawful activity, and in my opinion, shouldn't be allowed. But the Court of Appeals and the Supreme Court said, yeah, it's fine. Just give them an evidentiary hearing later on if they complain. That's what I got out of it.
That was interesting. Thank you.
Yeah, no worries. So things I got coming up. Saturday, we got a Lego stream with Rosalind Duke. And then on Monday, Nick and myself are starting a new trial that is here in Michigan. It's ex-Grand Rapids police officer that shot and killed a suspect in the back of the head, and he's pleading self-defense. So we have a new trial coming up for that. If you guys don't want to watch the Karen retrial again, or you can watch it on, in the evening after Karen retrial. But we're going to be streaming that starting on Monday. Yes, Lego time. It is Lego time. It's been too long. We're going to get back to some Lego. So, but yeah, Rosalind Duke is going to be joining myself, Valhalla, and Wendy H. So that'll be fun. Hella, what do you got coming up?
I've definitely got some more exhibits to go through from the Delphi trial because some more have dropped. So that'll be in the next day or so. I've got to cover some more Koberger rulings because the judge has come out with some stuff over the last couple of days. And guys, have a look in my Gene Hackman playlist because I'm dropping more body cams and things. So it's really interesting.
By the way,
No.
a link to Hella and Dolly's channels are in the channel description below. So if you guys want to find them, go over there, give them a sub, and check out their stuff. So you got more Delphi evidence. Nice.
Yeah,
Dolly,
heaps.
Sorry.
I just said heaps. Yeah.
Oh, heaps. Okay. Dolly, what do you got coming up?
Tomorrow I'm going to do a Lori Vallow stream on the juror interviews and potential problems that have arose from the jurors speaking, what they knew and when. So we'll play the interviews and talk about what they said and if it could lead to an issue for appeal.
I want to know when you're going to get the jail interview with Lori.
I know.
That's what I want.
I need to really play it up.
Do you have your press pass?
No, I need to make one for the second trial.
Yeah.
Get more official.
Yeah, get more official and then get in there for a jail interview with Lori. That would be amazing. You know she loves to talk.
She does.
She does.
Yeah, I did.
You could make that happen. That would be awesome.
I did talk to
That'd be amazing.
One of the women who interviewed Lori. She was there.
Oh, you got secondhand interview. Nice.
Yeah.
But you got to get to the real thing.
I know.
You got to see her eye to eye.
And I will
Not even on the phone. You got to like in person.
Can I just say I was like one of the only people there wearing a suit.
Well, that's good.
Oh,
You dress for the job you want,
yes.
Sal. You dress for the job you want.
I felt like I was very overdressed, but I think I looked
half
very
Irish
nice.
put in.
Thank you, Half Irish.
You.
There's so much drama going on with the Lori verdict.
Yeah.
Have you heard?
No, what's the drama?
The jurors knew. The jurors found out like at least the day before.
Yeah, you know what? Salvador and I were talking about that. Yeah, Salvador and I were talking about that. So here's the thing. Is it really realistic to know that not know who she was, right?
Yes.
We were talking about, okay, but we were also talking about like back in, in the early 1900s, right? When we started really getting these formalized courts, or even before that, like you have, like, think of Las Vegas, right? It's a small town. You've got, a couple hundred, maybe 1,000 people there. You had trials. Everybody knew everybody. The question is whether or not you can set that aside and actually judge the evidence. That's the real issue. So the fact that they knew that she was convicted or knew anything else isn't really relevant to impaneling a jury. And think about this, the Boston Massacre. All right. Everyone's heard of the Boston Massacre, even people in Australia. We have British soldiers shooting down innocent patriots, right? Before the Revolutionary War. There was a trial for them. They were charged with murder and assault with an intent to commit murder. By the way, our second president represented them as their defense counsel, and they were acquitted. They were acquitted. So even with the Boston Massacre and the uproar that we feel about the Boston Massacre, it was that strong at the time, and they were tried in that county, and they were still acquitted, even though the jurors probably knew all about it. The question is can they set aside all this other information and really just focus on the evidence? The problem with juries today is they just want to convict. They're just like, hey, tell me how he did it and I'll convict. You know, that's the problem with today. It's not that the jury doesn't know about these things outside. The question is can they honestly, truthfully look at the information that was presented at trial and decide based on that?
And we know they can't, right?
That was a different event, Valhalla.
So, okay, we know that like at least one of the jurors, and I'm hoping that all of them, but one of them said, I found out about it yesterday.
Well, right? The question is how do they find out about it?
Yeah.
Dolly was in the lunch line with them.
I was.
Right?
So they found out through Dolly.
No.
All right, now we know the source.
I did make a comment that I was surprised how easily accessible the jury was, and that I did make a joke in Discord about, should I ask that one of the jurors for an interview right now?
They were very easy to just speak to. They had no sign on them, no nothing.
Wait, did they have badges saying juror?
Not that I saw.
Like in Michigan, all of them wear these badges, these huge badges, bright yellow, black letters that says juror. So you know not to talk around them. You don't know if they're a juror in your case or someone else's case, but you don't talk around anybody with a bright yellow badge. And that's in every county I've ever been in. They have these giant badges.
How ridiculous.
It's like preschool when you have like these giant name tags so that the teachers don't lose track of all these toddlers running around. That's what it is for the jurors here.
Yeah.
So there you go. Like how easy is it for people to just be in line at lunch?
Yeah. And a juror has to wear it at all times they're on court property. So when you pull into the parking lot, you got to slap that on because you could be walking through the parking lot. People could be talking about it. And it's like giant yellow flashers. I'm a juror. Don't talk around me. I can't believe they don't have that.
Not that I noticed now.
Wow. Well, that should be exciting. I'm looking forward to that. Thank you both for joining me today. And
it's fun.
Yeah, guys, go check out Hella and Dolly. I can't guarantee quality content from Salvador, but it'll be entertaining at the very least. So, oh wait, I didn't set an exit video. Let me do that. Set an exit video. All right, guys, take care.
When I was young, my daddy said, gotta keep one eye open in your bed, 'cause there's a time coming when the devil gonna come for you. So my trigger